Ready, start. Leave granted full stop. Complainant is before this court challenging the order dated 25/4/2023 passed by the High Court of Madhya Pradesh at Gwalior, void which the order dated 11/1/2021 passed by the 4th Additional Sessions Judge, Shivpuri, quashing the summoning order dated 12/3/2019 passed by the trial court was set aside as far as section 420, IPC is concerned against the respondent number 1 and section 420 read with section 120 B, IPC against the respondent number 2 and respondent number 3, full stop. Briefly, the facts as available on record are that the marriage of the appellant was solemnized with the respondent number 1 on 28/4/2018 in the presence of the respondent numbers 2 and 3, full stop. Having come to know that on the date, the respondent number 1 had solemnized marriage with the appellant, she was already married and had not obtained divorce from her first husband, the appellant filed a petition under section 11 of the 1955 Act before Principal Judge, Family Court, Shivpuri within bracket MP bracket close, seeking annulment of marriage between the appellant and the respondent number 1, full stop. Subsequently, the appellant preferred a complaint against the respondent numbers 1, 2, and 3, in which the magistrate, void order dated 12/3/2019, after recording preliminary evidence and being satisfied that a prima facie case was made out, directed issuance of process against the respondent number 1 for the offences punishable under sections 494 and 420 read with section 120 B, IPC, and against the respondent numbers 2 and 3 for the offence punishable under section 420 read with section 120 B, IPC, full stop. The aforesaid order was impugned by the accused persons / respondent numbers 1, 2, 3 by filing revision petition before the 4th Additional Sessions Judge, Shivpuri, which was partly allowed by the Sessions Court, full stop. The impugned order dated 12/3/2019 passed by the magistrate was set aside to the extent of taking cognizance of the offence punishable under section 420 of IPC against the respondent number 1 and for the offence punishable under section 420 read with section 120 B of IPC against the respondent numbers 2 and 3, full stop. The appellant challenged the order of Sessions Court before the High Court, full stop. The same was upheld, full stop. It is against the aforesaid two orders, the appellant is before this court, full stop. Learned counsel for the appellant submitted that both the parties, namely the appellant and the respondent number 1, came in contact through a matrimonial site within bracket name withheld bracket close, and thereafter meetings were held at Visakhapatnam on 9/3/2018 and 10/3/2018 in the presence of the respondent numbers 2 and 3, full stop. The respondent number 1 was earlier married, as was even disclosed by her on the matrimonial site, full stop. At the time of meeting, the appellant was shown a smudged copy of the divorce order passed in favor of the respondent number 1 on mobile phone, full stop. On the document, the date could not be clearly seen as the copy of the order was not clear, full stop. It was stated that the order is pending signatures of the judge, full stop. Thereafter, the marriage of the parties was solemnized on 28/4/2018, full stop. The respondents dishonestly misrepresented that they are not financially well, and thereby induced the appellant to part with rupees 2 lakhs and bear the entire expenses of the marriage, full stop. On 16/6/2018, when respondent number 1 visited the doctor for a checkup, she was found to be pregnant, full stop. She wanted to undergo an abortion, but when confronted by the appellant, the reason therefore, she told that she had not yet obtained divorce from her previous marriage, full stop. The document which was shown to him on mobile phone was forged, full stop. This shows that the consent for marriage was obtained dishonestly, full stop. The appellant was taken aback, full stop, When confronted, comma, the respondent number 1 threatened him of filing false cases, full stop.